let's continue our discussion. Kung may questions pa kayo, ha? Mayroon ako mga sinasagot dito na questions sa chat box, no? Send directly to me. Pwede kayo mag questions pa. So let's proceed sa donor stocks. For donor stocks class, let's focus on these transfers and transactions constituting donations. Of course, number one, campaign contribution, because this year, 2022, is an election year. So ang rule natin dito, if you want to exempt, if a person contributed or donates something to a candidate, political party, or coalition, okay, para ma-exempt sa donor stocks, you have to report it to the COMELEC. And number two, the campaign contributions must be spent during the campaign period. Okay? Yun ang requirement natin dyan, dalawa. Duly reported to the COMELEC and spent during the campaign period. So we know the difference between an election period and the campaign period. In fact, wala pa tayo ngayon sa campaign period. So hindi pa exempted sa yung mga donations na binibigay sa mga kandidato. Okay? So yun lang ang requirement natin. Baka tanungin kasi nga election year ngayon. Report it to the COMELEC, and number two, spent during the campaign contribution. Okay? So kung ako yung donor at ikaw yung kandidato, ako yung subject sa donor stocks. Okay? Kaya nga yung mga kandidato nagsasubmit ng statement of contribution and expenses at the end of the election period para maipakita kung sino yung mga nag-contribute at kung nagamit ba nila lahat. Kung hindi mo in-report, subject sa donor stocks ang iyong campaign contribution. Okay? What about this one? Renunciation of inheritance. Okay? So let's take a look at this example. Si A and si B, husband and wife, they have 3 children, si X, si Y, at si W. Hindi naman requirement na sunod-sunod dapat sila. Okay, so sinong namatay? Si B. Okay, namatay si B. Kung titingnan natin yung property ni B, let's assume this is the property of B. Di ba i-divide natin yan sa 2, yung property nila? Because this 1/2 is the share on the conjugal property of the surviving spouse, while the other 1/2 will form part of the estate of the decedent. Ito yung inheritance portion. Right? Now, ito yung decedent natin na si B. Sa inheritance portion, dito sa estate, the surviving spouse is also an heir. Diba? So, 4 yung heir natin dito. The surviving spouse and the 3 children. So, this side is the inheritance. And this side is the share on the conjugal property. Kapag ang nire-renounce ay ang inheritance, ulitin ko lang ha, if what is being renounced is the share on the inheritance, you have to look at the type of renunciation, whether general or special. When you say general renunciation, you just repudiate the inheritance and you do not identify the person to whom these properties will go. Okay? Hindi mo sinabi kung kanino mapupunta. Sabi mo lang, ayaw kong tumanggap ng mana. Okay? When you say special renunciation, you identify the person or persons who will receive your share on the inheritance. Okay? So, the rule is, if you renounce an inheritance and the renunciation is general, that is not subject to donor stocks. But if the renunciation is special, in-identify mo kung kanino mapupunta yung property, yung share mo, yung mana ko, ibigay nyo na lang kay X. Okay? That is what? Donation. Okay? It is as if tinanggap mo yung mana pero ibinigay mo kay X. In that case, special renunciation is subject to donor stocks. Okay? Ulitin natin, kapag inheritance ang pinag-uusapan, renunciation of inheritance, determine whether renunciation is general or special. General renunciation of inheritance is not subject to donor stocks. Special renunciation of inheritance is subject to donor stocks. Okay? Now, pumunta tayo sa kabila. On the conjugal share of the surviving spouse. Okay? On the conjugal share of the surviving spouse. Kapag ang nire-renounce ng surviving spouse is the share on the conjugal property, Whether the renunciation is general or special, subject yan sa donor's tax. Hindi mahalaga kung anong uri ng renunciation. Kung ang nire-renounce ay share in the conjugal property. Okay? Pero kung inheritance ang nire-renounce, yan, titingnan mo, general ba or special? Pag general, not subject to donor's tax. Pag special, subject sa donor's tax. Okay? O, malino tayo dyan, ha? What do you mean by a deemed gift? Okay? Deemed gifts is a result of an indirect donation. Okay? Deemed gift is a result of an indirect donation. When you say indirect donation, the parties are not entering into a donation. They are entering into another transaction like sale, but not a donation. But along the way, due to the circumstances present, donation resulted. A good example of a deemed gift or an indirect donation is Section 100. Yung transfer natin, transfer of properties for less than full or adequate consideration in money. Okay? That is in case when the fair market value of the property is higher than the selling price of the property. The difference between the two is a deemed gift subject to donor's tax. Okay? The difference between the fair market value of the property and the selling price or the consideration received is considered as a deemed gift subject to donor's tax. But as amended by Republic Act 10963, if the transaction is a bona fide transfer or a transfer in an ordinary course of business, that is not subject to donor's tax. There is no deemed gift if the transaction is a bona fide transaction. Okay? Let's go to value added tax. Okay? Let's go to value added tax. Now, baka tanungin lang tayo ng simple question. What do you mean by cross-border doctrine or destination principle? Okay? It means what? Goods destined to be consumed here in the Philippines are subject to value added tax. When goods are destined to be consumed here, dito sa Pilipinas, i-consume. Dito sa Pilipinas, gagamitin. That is subject to donor's tax. Subject to VAT. Okay? Subject to VAT. But if the goods are destined to be consumed outside the Philippines, then that is not subject to value added tax. Take a look at importation. Ang importation, ang goods galing sa labas ng Pilipinas, outside, sa labas ng Pilipinas, papasok ng Pilipinas. So goods are destined to be consumed here in the Philippines. That's why importation is subject to value added tax. Okay? How about exportation? Goods are in the Philippines and to be taken out of the Philippines actually or constructively. So goods are destined to be consumed outside the Philippines. That's why export sale of goods are either zero rated or VAT exempt. In either case, walang output tax. Okay? So we cannot impose VAT on an export sale because the goods are destined to be consumed outside the Philippines. Okay? Zero rated ang export sale if the taxpayer is VAT registered. But if the taxpayer is non-VAT registered, the export sale is merely VAT exempt. And we know the difference between a zero-rated sale and an exempt sale. Pareho silang walang output tax. Pero ano ang pagkakaiba nila? Yung zero-rated sale ang pwedeng mag-claim ng refund ng input tax. Okay? Siya ang pwedeng mag-claim ng refund ng input tax. If the sale is a VAT exempt, hindi ka pwedeng mag-claim ng refund on input tax on your purchases attributable to that sale. Nakuha natin? Okay, yun ang pagkakaiba nila. Now, speaking of refund of input tax, very important. You have to master Section 112 of the tax code as amended. And you must know the concept of San Roque Power Doctrine, the Enhanced VAT Refund System, and BIR ruling number 489-03. Ito kasi ang general rule. Ito ang general rule. Ito ang exemption. Okay? Yan ang general rule, yan ang exemption. Okay? Now, let's talk about that section 112. refund of input tax. Okay, now, here are the requisites for the refund, for the claim of refund of input tax under Section 112. The taxpayer claimant must be a VAT registered. The sale must be zero rated or effectively zero rated. Kailan nagiging effectively zero rated? If pursuant to a special if pursuant to a special law or international agreement on which the Philippines is a signatory, the sale is effectively made as zero rated. So kailangan may special law or international agreement, okay, for it to be considered as zero rated. Now, input taxes are incurred or paid. Such input taxes are attributable to zero rated or effectively zero rated sale. Input taxes are not applied against output VAT, and the claim for refund is filed within the prescriptive period. It is filed within the prescriptive period. Okay? Hold on, class, ha? Magdadagdag lang ako ng slide. Okay. So, i-apply natin yung section 112. If you will be asked, what is the prescriptive period to file an administrative claim for refund of input tax? Why administrative claim? Because you are filing it before the Bureau of Internal Revenue, which is an administrative agency. Kaya administrative claim. Pag umakyat ka na ng korte, you seek judicial relief. That is now a judicial claim. Okay? Malinaw tayo doon. So what is the prescriptive period to claim refund under Section 112? The answer is 2 years. But as I am telling my students always, okay, and paulit-ulit, every time may period na pinag-uusapan, isama mo sa sagot mo ang reckoning point. Okay? Not only in tax but in all other laws, if the answer requires a period, include the reckoning point. Kailan magsisimula ang period na yan so that your answer is complete. So, the 2-year period to file a claim for refund of input tax is 2 years from the close of the quarter when the sales are made. Okay? 2 years from the close of the quarter when the sales are made. Okay? So kung meron kang sale ng January, February, March, kailan magsisimula ang 2 years mo? April 1. Because this is the close of the quarter and this is the start of the close of the quarter. So kung meron, this is first quarter. Yung second quarter mo, April, May, June. Kung meron kang sales during the second quarter, kailan magsisimula ang 2-year prescriptive period mo? July 1. Kung meron kang sales sa third quarter, July, August, September. Kailan magsisimula ang 2 years mo? October 1. Diba? Fourth quarter, October, November, December. Kailan magsisimula ang 2-year period mo? January 1 of the following year. Okay? So sa loob ng isang taon, 4 na beses pwedeng tumakbo ang 2-year prescriptive period mo. Dahil per quarter ang bilangan natin dyan. Okay, may sariling 2-year ito. May sariling 2-year period yan. May sariling 2-year period to. May sariling 2-year period yan. Okay, nakuha natin? So the prescriptive period is 2 years from the close of the quarter. Okay. Assuming the period involved is 2015. First quarter sale. January, February, March. So the 2-year period will commence on April 1, 2015 until March 31, 2017. Yan ang 2-year period mo. Okay? April 1, 2015 up to March 31, 2017. You can file dito. Pwede kang mag-file sa umpisa pa lang, walang problema. Pwede kang mag-file sa gitna ng 2-year period. Pwede kang mag-file sa last day ng 2-year period at walang problema dyan. Walang problema dyan. Ang mahalaga, when you file your admin claim, your administrative claim for refund sa Bureau of Internal Revenue, pasok ka sa 2-year period. Pasok ka sa 2-year period. Now, you file your application with the Bureau of Internal Revenue, and the Bureau of Internal and your application must include all your supporting documents. Because after you file your claim for refund, the BIR has a period of 120 days under the old rule, 120 days to decide your claim for refund. And that 120-day period is counted from the date of complete submission of the supporting documents. Okay? The submission of the complete documents. Sino ang makakapagsabi na kompleto na ang dokumentong isinusumiti mo sa BIR? The BIR or the taxpayer? Ang sabi ng Supreme Court, the taxpayer. Okay? Ang taxpayer ang makakapagsabi kung kompleto ang dokumentong sinasubmit niya or hindi. Kasi siya ang makakapagsabi kung ano mga dokumento ang gusto niyang isuporta sa claim niya. Okay? Pero ang tanong, paano naman malalaman ng BIR na kompleto na ang dokumentong sinusumite ng taxpayer? Okay? In the recent issuance, in Revenue Memorandum Circular 54-2014, issued by the Bureau of Internal Revenue. Ang sabi ng BIR, when you apply for claim for refund of input tax, okay? You must include a sworn certification or a sworn statement that the documents you are submitting are complete already. Magsusumiti ka ng sworn statement na kompleto na ang dokumentong isinusumiti mo or isinasubmit mo. Kung wala yung sworn statement na yan, hindi tatanggapin ng BIR ang application mo because the documents are not yet complete. Okay? At kung hindi pa yung kompleto, hindi tatakbo ang 120 days ng BIR to decide. Okay? So yun ang requirement. Magsumiti ka ng dokumento at mag-submit ka ng sworn statement na kompleto na ang documents, na kompleto na ang supporting documents mo. At hindi ka na magsasubmit pa later on. Okay, nag-submit ka ng application with supporting documents, with sworn certification na receive na ng BIR. Upon the receipt of the BIR, they have 120 days to decide your claim for refund. They have 120 days to decide your claim for refund. Dalawa ang pwedeng mangyari sa loob ng 120 days. There might be a decision on your claim for refund or natapos yung 120 days nang walang desisyon. We call it inaction. And inaction is what? Deemed denied ang claim for refund mo. Now, dito muna tayo. May decision. If there is a decision adverse to you on your claim for refund, you have a period of 30 days to file an appeal to the CTA division. You have 30 days to file an appeal to the CTA division. Okay? In case of inaction, upon the expiration of the 120-day period, you have 30 days as well to file an appeal to the CTA division. So this is what you call as the 120 plus 30-day period, also known as the San Roque Power Doctrine, where the Supreme Court said that the 120 plus 30-day period is mandatory and jurisdictional. Meaning to say, you have to allow the BIR to decide your claim for refund within a period of 120 days before you elevate it to the Court of Tax Appeals. Okay? And what principle is that? That is the principle of exhaustion of administrative remedies. Because you still have an administrative remedy, magpunta ka muna sa BIR. Mag-file ka muna ng claim sa kanila. And may 120 days ang BIR to decide. Okay? Kung hindi pa tapos yung 120 days, at wala pang desisyon, hindi pa tapos, wala pang desisyon, huwag kang aakyat sa CTA. Because if the 120-day period is not yet expired, and you elevated it to the CTA, you file an appeal to the CTA will dismiss your appeal on the ground of what? Lack of jurisdiction. Because your petition is prematurely filed. You failed to exhaust your administrative remedy. Hindi pa tapos yung 120 eh. Umakyat ka na kagad. I-dismiss namin yan. Wala pa kaming jurisdiction dyan, sabi ng CTA. Premature yung filing mo. Hintayan mong matapos yung 120 days. I-exhaust mo yung remedy mo bago ka umakyat sa amin. Sa loob ng 30 days. Pagkatapos ng 120. Kaya nga 120 plus 30. Nakuha natin? Okay? Ngayon, pagkatapos ng 120, may 30 days ka. Dapat makaapila ka sa loob ng 30 days. Okay? Dapat makaapila ka sa loob ng 30 days. Nakuha natin? Bakit sa loob ng 30 days? Kasi pag nalampasan mo yung 30 days, ang sasabihin naman ng Court of Tax Appeal sa'yo, wala kaming jurisdiction dyan. Bakit? Prescribe na yung right mo. Okay? Prescribe na yung right mo sa 30-day period. Okay? Wala na rin kaming jurisdiction dyan because your right to seek judicial relief has already prescribed. So you must observe the 120 plus 30-day period which is mandatory and jurisdictional. Nakuha natin? And that is what you call as what? The San Roque Power Doctrine. But we have now what we call as the enhanced VAT refund system under the train law. And under the train law, the period to decide of the BIR is no longer 120, but it is now 90 days. Okay? The BIR has a period of 90 days to decide. Okay? And after the period of 90 days, merong adverse decision, you have a 30-day period to appeal to the CTA. So yung dating 120 plus 30, 90 plus 30 na ngayon. Baka kasi tanungin ka, distinguish San Roque Power Doctrine versus the enhanced VAT refund system. O yun ang sagot, 120 plus 30 versus 90 plus 30. Okay? So dagdagan natin ng konti. Kung babalikan mo yung tax code of 1997 sa section 112, letter C, may nakalagay dyan, kapag natapos na yung 120 days at walang desisyon ng BIR, ang tawag natin doon inaction, you have 30 days to appeal to the CTA. Tama? Pero under the train law, under Republic Act 10963, that provision was excluded. Sa amendment ng Republic Act 10963, wala lang nakalagay na upon the expiration of the 90-day period, you have 30 days to appeal. Ang nakalagay doon, kapag hindi na nakapag-desisyon ng BIR sa loob ng 90 days, may disciplinary action ang BIR officer pag hindi mo na-desisyonan sa loob ng 90 days. Pero kung walang desisyon, ano ang remedy ng taxpayer? Kung tinanggal yun sa train law, ang ibig sabihin ba nito ay wala na tayong remedy in case of inaction of the BIR doon sa claim for refund natin? The answer is no. We still have a remedy, and that remedy is to file an appeal to the CTA within 30 days. And our basis is no longer the tax code or the train law, but a special law. And that special law is Republic Act 1125 as amended by Republic Act 9282. The law that created the Court of Tax Appeals and expanded the jurisdiction of the Court of Tax Appeals. Here. Okay? The Court of Tax Appeals was created by Republic Act 1125. Republic Act 9282 expanded the jurisdiction and elevated the status of the Court of Tax Appeals with the same rank of the Court of Appeals. Dati kasi, ang desisyon ng CTA, appealable pa sa CA bago ka mag-Supreme Court. But under RA 9282, the CA and the Court of Tax Appeals, same level na lang sila. Kaya ang desisyon ng CTA, appealable na sa Supreme Court, no longer sa Court of Appeals. And dito sa RA 9503, it expanded the organizational structure of the Court of Tax Appeals. Dati kasi, 6 justices lang dito. But under RA 9503, ginawa ng 9 justices ang Court of Tax Appeals. As I have told you, doon sa Republic Act 112, as amended by train law, wala man yung provision ng inaction sa Section 112C. But you have a remedy under RA 9282. Because ang sabi dyan sa Section 3 of RA 9282, the CTA has exclusive jurisdiction on the commissioners in action. Nandito. And inaction is defined as the failure of the commissioner to decide within a period given by the law. Okay? So may remedy ka pa rin sa inaction na, but no longer under the tax code or under the train law. But it is now under the special law, and that is RA 9282. Okay? Malinaw tayo dyan, ha? Malinaw tayo dyan. Dyan sa remedy natin sa tax refund, refund of input tax under section 112. Ulitin natin, ha? Okay? You have a period of 2 years to file an admin claim for refund. The BIR has a period of 120 days or under the train law, 90 days to decide your claim for refund. And in case of adverse decision or inaction, you have 30 days to go to the CTA division. Ha? Division, ha? Hindi sa NBank. Okay? Division muna tayo bago ka magpunta ng NBank. Kung talo ka sa division, mag-MR ka sa division. Okay? By the way, class, ha? Pag umapila tayo sa CTA division, this is via Rule 42 of the Rules of Court. Okay? Talo ka sa division, mag-MR ka. Denied yung MR mo, o pwede kang umapila from the CTA division to the CTA NBank via Rule 43 of the Rules of Court. Denied, talo ka sa NBank, mag-MR ka. Denied yung MR mo, pumunta ka na sa Supreme Court via Rule 45. Okay? Petition for review on certiorari. Okay? So 42, 43, 45. CTA division, CTA NBank, and then Supreme Court. Okay? So mula sa Agham Road, kasi ang CTA ay nasa Agham Road. Saan ka pupunta? Pupunta ka ng Padre Paura. Dahil nandoon naman ang Supreme Court. Pero wag niyong ilalagay yon sa inyong sagot. What is your remedy in case of denial of the Court of Tax Appeals? You don't say that from the Agham Road, you file an appeal to the Padre Paura. Okay? Wala lang yon. Biyahe lang yon. Okay? Now, this is the exception to the rule, yung 489-03. Di ba ang rule natin? You wait for the BIR to decide within a period of 120 days or 90 days before you file an appeal to the CTA within 30 days. Mandatory and jurisdictional. But there is an exception to that rule. That is, ang sabi sa exception na yon, kahit hindi pa tapos yung 120-day period mo, okay, pwede ka nang umapila sa CTA kahit hindi pa tapos. And that is pursuant to BIR ruling 489-03. Kaya lang, class, yung DA 489-03 has a very limited period of application. And that is from December 10, 2003 to October 6, 2010 only. So ngayon, at present, hindi na applicable yan. Pero kung biglang magbigay sa problem na nag-fall dito sa period na to, ang claim for refund, then the 120 plus 30 day is not mandatory and jurisdictional. You can invoke DA 489-03 as an exception to the rule, which means without waiting for the expiration of the 120-day period, umakyat ka na sa CTA. Okay? Umakyat ka na sa CTA. Okay? Few reminders on remedies. Okay? Of course, the case of Sony Philippines and Medicard Philippines, no? The importance of a letter of authority. You need the letter of authority to conduct an examination of a taxpayer to issue an assessment. Under the tax code, it is the Commissioner of Internal Revenue who is authorized to examine the books of accounts and accounting records of the taxpayer. But the Commissioner of Internal Revenue is only one. Hindi niya kayang gawin yan. That's why dinedelegate niya ang pag-e-examine sa mga taxpayer. And how is it done? Through the issuance of a letter of authority. If there is a notice of discrepancy issued, a preliminary assessment notice issued, a FAN issued, or a final decision on disputed assessment issued without a letter of authority, that is a null and void assessment. Okay? That is a null and void assessment. Okay? Remember, class, an assessment issued without a letter of authority is a null and void assessment. Okay? Nakuha natin? Now, here is the stages of assessment and taxpayers remedy. Familiarize yourselves with section 228 of the tax code. So it begins with the issuance of a letter of authority, the conduct of the audit, and the BIR will now issue a notice of discrepancy. Ang tawag natin dyan previously sa notice of discrepancy is notice of informal conference. Okay? If you will be asked, is the issuance of a notice of discrepancy mandatory? The answer, class, is under the present rule. Under the present rule, the issuance of notice of discrepancy is mandatory. But there was a time, that the issuance of notice of discrepancy is not part of due process requirement. And that is during the effectivity of Revenue Regulation 18-2003 na tinanggal ang requirement ng notice of informal conference. So kung nabasa mo yung case ng Commissioner of Internal Revenue versus Fitness by Design, Inc., ang sabi doon ng Supreme Court, mandatory and jurisdictional ang notice of informal conference, because that case was decided during the time that the revenue regulation effective requires or mandates the issuance of a notice of informal conference. Pero kung ngayon itatanong yan, 2022, mandatory and jurisdictional ba? Mandatory bang issuance ng notice of discrepancy? The answer is yes. That is mandatory part of due process requirement, the right to due process of the taxpayer. Okay, if you violated the right to due process of the taxpayer as held by the Supreme Court in the case of Commissioner of Internal Revenue versus Avon Products Manufacturing Inc., ang sabi ng Supreme Court, pag violate mo ang right to due process, okay, the assessment is null and void. Okay? After the issuance of the notice of discrepancy, hindi kayo nagkasundo ng taxpayer, you are still disputing the findings of the examiner, the preliminary assessment will be issued. The preliminary assessment must be in writing. It must contain the law, the rules, and regulations on which the assessment is based. Okay? The issuance of the PAN is required. But there are instances where issuance of the PAN is not required. There are 5 instances enumerated in Section 228. Mga mathematical error, etc. So you pay visit sa Section 228 kung saan hindi na required ang issuance ng PAN. Okay? Upon the receipt of the PAN, the taxpayer has 15 days to file a reply. Take note, class. The issuance of the PAN is mandatory, but filing a reply to the PAN is optional. Okay? Hindi mandatory ang pagpa-file ng reply. Ang mandatory, mag-issue ang BIR ng PAN. Okay? Ang taxpayer may or may not file a reply. Kasi kung hindi magpa-file ng reply ang taxpayer, the taxpayer is considered in default. Take note, class, kapag ang taxpayer ay hindi nag-file ng reply, the assessment is not yet final, executory, and demandable. It's not yet final, executory, and demandable. The taxpayer is merely considered in default. And what is the effect? If the taxpayer is considered in default, the FAN or the formal assessment notice will be immediately issued. Okay? At kapag na-issue ang FAN, okay? Kapag na-issue ang FAN, dito mandatory ang protest. Because pag hindi ka naka-file ng protest, dyan magiging final, executory, and demandable ang assessment. Kaya baka tanungin ka, distinguish PAN from FAN or distinguish reply from protest. That's the answer. Okay? The formal assessment notice must also be in writing. It contains the law, the rules, regulation on which the assessment is based. It must be dated. It must contain a demand to pay. And there must be a definite due date for the payment. In several cases, decided by the Court of Tax Appeals, pag walang demand, void ang assessment. Pag walang definite deadline, definite due date kung kailan magbabayad, void ang assessment. In fact, in one case, the Court of Tax Appeals invalidated the assessment for being undated. Walang date. Ang sabi ng CTA, kung walang date yan, paano mo kukumputin yung interest? How will you compute the interest if there is undated? If that is undated? Okay? The demand must be definite. The amount must be certain or at least determinable. Okay? So, dated, it must contain a demand and a definite due date on top of being on writing, containing the law, the rules, and regulation. Plus, naalala mo ba, sa Section 203 ng Tax Code, the government should be able to make an assessment for a period of 3 years under the ordinary circumstance and 10 years under the extraordinary circumstance. Naalala? Okay? Under jurisprudence, dapat makapag-issue ang BIR ng fund sa loob ng 3 taon para ma-consider na assessment is made. Okay? It is not the issuance of the letter of authority within 3 years, the audit within 3 years, the notice of discrepancy within 3 years, or the PAN within 3 years. In the case of Commissioner of Internal Revenue versus Transitions Optical Philippines Incorporated, the Supreme Court said that it is the formal assessment notice that must be issued within the prescriptive period of 3 years. Otherwise, if the fund is issued after the 3-year prescriptive period, it is already null and void for being issued beyond the prescriptive period. It is already barred by prescription. Nakuha natin, ito ang dapat mong ma-issue sa loob ng 3 taon. Doon sa prescriptive period na sinet ng Section 203 of the Tax Code. Okay? What do you do after the issuance of the PAN? After the receipt of the PAN, magprotesta ka within 3 days. Whether reconsideration or reinvestigation. And how do we distinguish reconsideration from reinvestigation? Okay? Pag reconsideration, that is a plea of evaluation of existing records without giving the BIR additional records. Wala ka lang idadagdag pang dokumento. Sa request for reinvestigation, okay, magdadagdag ka pa, magsasubmit ka pa ng newly discovered or additional evidence. In both instances, you can raise question of law or fact or both. Okay? Sa request for reconsideration, you can avail this even without the approval of the Commissioner of Internal Revenue. Sa request for reconsideration, approval of the Commissioner of Internal Revenue is required. Okay? Sa request for reconsideration, it does not suspend the prescriptive period to collect of the BIR. While the same is suspended kapag sa reinvestigation. Sa reconsideration, no need to submit additional evidence. Okay? Sa reinvestigation, 60 days to submit additional evidence. Okay? And upon the submission, may 180 days ang BIR to decide. At kung hindi pa tapos ang 180 days ng BIR to decide at wala pang decision, huwag ka na namang aakyat sa CTA. Failure to exhaust administrative remedy na naman yan. I-dismiss lang yan. Premature. So, intayin mo. Dalawa kasi ang pwedeng mangyari sa loob ng 180 days. Magkaroon ng desisyon or inaction. Pag mayroon ng desisyon, 30 days from the receipt of the adverse decision, umakyat ka na sa CTA division, and then en banc, and then Supreme Court. Okay? Nakuha natin? Okay? But let us expound more of that. Okay? What is your remedy in case of an FDDA? To answer that, alamin mo kung sino ang nag-decide o magdi-decide ng protest mo. Okay? Alamin mo kung sino ang nag-decide o magdi-decide ng protest mo. Is it the commissioner or the commissioner's duly authorized representative? Umpisahan natin. Kung ang magdi-decide o nag-issue ng decision is the commissioner's duly authorized representative. Okay, dito tayo ha. Commissioner's duly authorized representative. If there is an adverse decision, you have the option to file a motion for reconsideration to the Commissioner of Internal Revenue or appeal to the CTA within 30 days. Okay? So yung authorized representative na nag-decide, pwede kang umakyat sa commissioner, mag-MR ka, mag-motion for reconsideration ka within 30 days. Allowed yan. Pero wag kang mag-motion for reinvestigation to the Commissioner of Internal Revenue. That is not allowed. Nakuha natin? Ang isang option mo pa, from the Commissioner's duly authorized representative, umakyat ka na sa CTA within 30 days from the receipt of decision. Okay? Again, in case of adverse decision, either you file an MR to the Commissioner or appeal to the CTA within 30 days from the receipt of the adverse decision. Okay? Now, what if in action, natapos na yung 1/8, wala pang desisyon, ang Commissioner of Internal Revenue, okay? Ang Commissioner So, kapag may inaction, dalawa ang option mo, maghintay or umapila na. So sabihin mo sa BIR, 180 days na, wala ka pang desisyon. Alam mo, BIR, para kang yung girlfriend ko na magbabar ngayong taon. Ha? Hinihintay ko siya, wala pa siyang desisyon kung magpapakasal kami or hindi. Hihintayin ko siya. Okay, hanggang sa makapag-decision siya. And if the decision is adverse, I will appeal to the CTA within 30 days. Kahit gaano pa katagal yan, kahit mausod-usod pa ang bar exam, wag naman sana last na ito, nausod, no? Hihintayin ko yan. At kapag adverse ang decision, aapil ako within 30 days. Yan ang first option mo, maghintay. Sanay ka naman dyan yung pinaghihintay, di ba? So, maghintay ka na ng matagal, 30 days to appeal kapag nakatanggap ka na ng desisyon. Ang isang option mo naman, pagkatapos ng 180 days, umapila ka na sa CTA within 30 days. So it's either you wait, mahaba kasi pasensya mo, maghihintay ka. Pangalawa, umapila ka na. Ang tanong, class, gaano katagal kang maghihintay hanggang sa makapag-decide ang BIR? Ang sagot, walang period provided sa rules. Ibig sabihin, kung gaano katagal, pwede. To tell you honestly, meron akong protest final noong 2016. Hanggang ngayon, wala pang desisyon. Di ba? Sasabihin mo, sir, nung natapos yung 180 days, bakit hindi kayo umapila sa CTA within 30 days? Hindi kami makakaapila. Bakit? Ang laki ng assessment. Ang laki ng pambayad ng filing fee sa court. Kaya nag-decide na lang kaming hintayin yung decision nila. At baka manalo kami sa protest. O, di ba? O kaya, i-reduce yung assessment, saka kami aapila sa CTA. May mga reasons kung bakit ayaw mong umakyat ng court. Magbabayad ka ng filing fee, which is irrecoverable na. You cannot recovered it na. Pag nagbayad ka sa filing fee. Kung 15 billion yung assessment sa'yo, magkano ang filing fee mo sa court? Ang laki. Di ba? Magbaban ka pa. Di ba? Babayad ka pa ng premium. So sabi mo, wag na lang tayo umapila sa court. Hintayin natin mag-decide. Yung BIR. Baka babaan yung assessment. Di ba? So may mga reasons kung bakit natin hinihintay. Ulitin ko lang for clarity. Commissioner's duly authorized representative. Adverse yung decision. You have an option to file a motion for reconsideration or appeal to the CTA within 30 days from receipt of the decision. In case of inaction, you have the option to wait for the decision, and upon the receipt of the adverse decision, 30 days to appeal to the CTA division. Or upon the expiration of the 180-day period, umapila ka na sa CTA. Based on the case of Las Cuna Land versus Commissioner of Internal Revenue as reiterated in RCBC versus Commissioner of Internal Revenue, these options are mutually exclusive. Okay? What if ang nag-decide ay ang Commissioner of Internal Revenue? Okay? What if ang nag-decide ay ang Commissioner of Internal Revenue? Huwag kang mag-EMR sa desisyon ng Commissioner of Internal Revenue. That is a wrong remedy. Because filing an MR to the decision of the Commissioner of Internal Revenue will not toll the 30-day period to appeal to the CTA. Tandaan mo yan. Kapag CIR ang nag-decide, the only remedy you have is to file an appeal to the CTA within 30 days. No MR to the Commissioner of Internal Revenue. Wrong remedy. As held by the court in Fishwell Canning Corporation versus Commissioner of Internal Revenue. Okay, again, the motion for reconsideration to the Commissioner of Internal Revenue does not toll the running of the prescriptive period to appeal to the CTA. Nakita mo yung pagkakaiba? Kasi dito sa duly authorized representative, pwede ka mag-MR sa Commissioner of Internal Revenue. Pero kung Commissioner of Internal Revenue na nag-decide, walang MR. Apila lang. Okay? In case of inaction, same remedy. Wait until there is a decision, then appeal within 30 days. Or upon the expiration of 180 days, appeal to the CTA within 30 days. Okay? So yan, ang mga remedies mo, depende kung sino ang nag-decide o sino ang mag-decide. Now, some cases, ito binanggit ko na to sa inyo kanina, Avon Products Manufacturing, the right to due process of the taxpayer. Okay? If the right to due process of the taxpayer is violated, the assessment is null and void. Briefly, ano bang nangyari dyan sa Avon Products na yan? Kasi pag ganito ang pattern ng tanong sa'yo, alam mong Avon Products Manufacturing ang tinatanong. Ano nangyari dyan sa Avon Products? Nag-issue ng Notice of Informal Conference. Informal conference pa nun. Okay? Challenge ng taxpayer. Nag-file ng reply, nag-submit ng supporting documents. Afterwards, nag-issue ang BIR ng PAN. Ang assessment sa PAN, exactly the same as that contained in the Notice of Discrepancy, except in-update ang interest. What did the taxpayer do? Nag-file ng reply, challenge yung PAN, nag-submit ng supporting documents. Okay? What happened next? Nag-issue ang BIR ng FAN. Ang laman ng FAN, exactly the same sa laman ng PAN at exactly the same sa laman ng Notice of Discrepancy, except that updated yung interest. But the FAN is silent as to the supporting documents of the taxpayer. Ang sabi ng Supreme Court, okay, bakit ko binanggit itong Avon Products? Kasi si Justice Leone ang ponente nito. Ang sabi ng Supreme Court, the proceedings before the BIR is an admin proceeding. And there are rules that you have to follow in administrative proceedings as laid down in the case of Ang Tibay. Diba? The Ang Tibay case, okay, na nag-provide ng administrative due process. And one of the requirements in administrative due process is that the decision of the administrative agency must consider the evidence submitted by the party. As applied in this case, ang sabi ng court, hindi nyo kinonsider yung ebidensyang isinabmit ng taxpayer. Okay? Your FAN or your PAN should state kung bakit inapplicable or unacceptable ang evidence ng taxpayer. Okay? You simply ignored the supporting documents of the taxpayer and reiterated, in fact, almost copy-paste yung assessment niyan. So the taxpayer is not informed kung bakit hindi acceptable yung mga supporting documents niya. So you violated the right of the taxpayer to due process. In that case, okay, the assessment is declared as null and void. So kung ganun yung problem pattern, nag-issue ng Notice of Discrepancy, exactly the same as the PAN, exactly the same as the FAN, inignore ang evidence ng taxpayer, hindi inexplain kung bakit bakit hindi acceptable or not hindi na-admit yung evidence, Avon Products na ang tinatanong dyan. And the issue there is the right to due process of the taxpayer. Okay? Now, another case, the case of Commissioner of Internal Revenue versus BY Domingo. Simple lang ang nangyari dito. Yung taxpayer naka-receive ng FAN. Anong ginawa niya nung ma-receive niya yung FAN? Umapila sa CTA. Ganun na nangyari. Ano ang sabi ng CTA? Lack of jurisdiction. Wala kaming jurisdiction sa FAN. Ang may jurisdiction sa FAN ay pag nag-file ka ng protest, CIR ang may jurisdiction dyan. Okay? Ang jurisdiction ng CTA ay nasaan? Sa FDDA. Yan ang jurisdiction namin. FDDA or inaction. Nakuha natin? So kapag ang problem na binigay sa'yo, FAN, okay? Pagka-receive ng FAN, umakyat na sa CTA, BY Domingo G. Wheeler na yan. Okay? Walang jurisdiction ng CTA dyan. Because ang FAN, may administrative remedy ka pa sa FAN. Di ba ang rule natin, ex hoc, administrative remedy? Pag naka-receive ka ng FAN, may administrative remedy ka pa? Oh yes. And what is your administrative remedy? File a protest sa Commissioner of Internal Revenue. Huwag kang aakyat sa CTA. Walang jurisdiction ang CTA sa FAN. Okay? Ang jurisdiction niya, final decision on disputed assessment or inaction. Nakuha natin? Okay. Next. Refund of tax illegally or erroneously collected. Okay? Refund of tax illegally or erroneously collected. Again, the period here is 2 years. The period of 2 years counted from the date of erroneous payment. Okay. Oh, wag malilito ha. Doon sa section 112, refund of input tax, 2 years from the close of the quarter where the sales occurred. Dito sa section 229, refund of tax illegally or erroneously collected, 2 years from the date of erroneous payment. If the tax is payable on installment, the 2-year period is counted on the date of last installment payment. Okay? Ano ba mga example ng tax payable on installment? Regular corporate income tax. Di ba nagbabayad ka ng first quarter, second quarter, third quarter? Oh. Kung may erroneous payment ka doon, kailan mo i-count? Di on the last payment. That is the 2-year period. Okay? Now, assuming. Yan, assuming. Okay? Assuming. April 1, 2015, nag-start yung 2-year period. Kailan matatapos ang 2-year period niyan? March 31, 2017. Yan. 2-year period niya yan. Okay? 2-year period niya yan. Sa loob ng 2 years na yan, dapat makapag-file ka ng claim for refund of tax illegally or erroneously collected. Halimbawa, January 1, 2016, nag-file ka ng claim for refund. Pasok sa 2 years? Yes, pasok sa 2 years. Okay. What if na-receive mo yung adverse decision denying your claim for refund February 1, 2017. Kung February 1, 2017, you have 30 days to file an appeal to the CTA. And that 30-day period is until March 2. Kasi February has 28 days. March 3. Hanggang March 3, ang 30 days mo to file an appeal to the CTA. Okay. Now, what if na-receive mo yung adverse decision March 1, 2017? Do you still have 30 days to file an appeal to the CTA? Yes. You have until March 31 to file an appeal to the CTA. What if na-receive mo yung decision March 15, 2017? Do you still have 30-day period to file an appeal to the CTA? No more 30 days. But you have what? 16 days only or until March 31 to file an appeal to the CTA. Okay? Hindi ka po pwedeng lumampas ng 2 years ang claim mo for refund, both administrative and judicial. So yung pagpa-file mo sa BIR at ang pag-akyat mo sa korte, dapat nakapaloob yan, nakapasok yan sa loob ng 2 taon. Kaya nitong unang mga illustration ko, may 30 days ka pa to file an appeal to the CTA dahil pasok ka pa sa 2 years. Dahil pasok ka pa sa 2 years. Pero nung na-receive mo yung decision ng March 15, wala ka ng 30 days dahil ang 2 years mo hanggang March 31 na lang, 2017. Nakuha natin? Okay? The 2-year period shall cover the administrative and the judicial claim. Kung mapapansin mo, sa refund of tax illegally or erroneously collected under Section 229, may walang period to decide ang BIR. Sa 112, sa refund of input tax, may period to decide siya. 120, ngayon 90. Sa Section 228, protest of an assessment, may period to decide siya. 180 days. Pero sa refund of tax illegally or erroneously collected, walang period to decide. Bakit walang period to decide? Dahil nakapaloob na yan sa 2-year period. Bakit kailangan mong makapag-file ng administrative claim and judicial claim for refund within a period of 2 years? Because Section 229 provides that the refund of tax illegally or erroneously collected shall be for a period of 2 years, okay, regardless of any supervening events. Because the tax code says, regardless of any supervening events. Kahit anong mangyari, dapat makaakyat ka sa CTA within 2 years. Otherwise, prescribed na yung right mo. So kung matatapos na ang 2 years at wala pang desisyon ng BIR sa claim for refund mo, umakyat ka na sa CTA. Huwag mong hintayin matapos ang 2-year period mo. Nakuha natin? Malinaw. Okay? So you should be able to distinguish Section 112 refund of input tax, Section 228, protest of an assessment, and Section 229, refund of tax illegally or erroneously collected. Huwag papasok sa bar exam site nang hindi kabisado ang tatlong provision na yan. But I know at this point in time, kabisado mo na yan. Kahit natutulog ka, alam ko, mapapanaginipan mo yan mamayang gabi. Distinguishing Section 112, 228, and 229. At sana ilabas naman sa bar exam ang mga tanong na yan. Okay? Para makuha natin yung tamang sagot. Nakuha ba natin, class? Okay. Now, I've discussed this already with you, the Court of Tax Appeals, the law that created it, that expanded its jurisdiction, and that expanded the organizational structure. Okay? I want you to read this. I leave it up to you, the exclusive jurisdiction of the Court of Tax Appeals. The jurisdiction of the Court of Tax Appeals. That is Section 3 of Republic Act 9282. Okay? Jurisdiction sa criminal case and jurisdiction over tax collection cases. Okay? So, those are the things I believe are important to you when you take the bar exam this year. So, if